Every week I ask an attorney about an area of the Constitution, case, issue, something like that they're interested in about the Constitution, and share that with our listeners. What did you choose to talk about today?
Well, Steve, there is a section in our Constitution about patents, but what I'm talking about isn't directly related to that. It's really about a case that where the attorneys have petitioned for the U.S. Supreme Court to hear it as a matter of what we call statutory interpretation. And the reason that I thought it would be of interest is because it's creating what the appellate court, the federal circuit, which hears patent cases in our country, their decision, and I was talking earlier about you have to have a complete description of your invention, and closely related to that is somebody who's in a particular area of expertise of the patent has to be able to recreate the invention in the patent without what is known as undue experimentation. Well, the Federal Circuit, in this case called Amgen versus Sanofi, said no. You want to protect a certain kind of antibody that you've bioengineered, but you really and I'm not going to go into the weeds and the technology
Well, thank
because
you.
that's really not going to help us with a brief description. You don't have a sufficient manner in your patents of how to make these antibodies because generally what we would want to see is a structural description. For those of you who don't know what you probably do know what antibodies are. They're those molecules that circulate in your body that fight infections and getting cancer. They attack cancer cells, and there's so many different kinds, and there's so many that have been bioengineered and are actually parts of the medication you take. So this is like going backstage at an opera. You know what you take the drugs. Most of them are prescription, unless they're just off what is known as off patent. You take them, hopefully you feel better, and you don't really know what went into making them or initially protecting them. So there's the whole patent aspect of protecting these remedies and these medications. And of course, they have to stick to the same patent rules as everybody else. So the Federal Circuit said, you haven't told us how to make it. You've told us that they have to function in a certain way, but you haven't told us how to create them. And that's a problem because you want to protect what's actually millions of antibodies, but you haven't told us how to make a representative number. First, you haven't told us how to make a representative number of them, of the millions. And secondly, you haven't given us sufficient guidance to even figure it out for ourselves. So that's what the Federal Circuit said. The patent owners are absolutely infuriated. Surprise, surprise. So it'll be interesting to see if the Supreme Court takes this case. They've given it to the solicitor, someone called the Solicitor General, to weigh in before they make any decisions. So that's where we are right now.
Well, I'm always amazed at the Supreme Court at the breadth of the decisions that they have to make, from these patent decisions to bankruptcies. We talk about to every area of the law, and how those practices sometimes will be critical of the Supreme Court because they're not in that area of the law, yet they're making all the rules about it. It gets very complicated. So thanks so much for sharing that case with us.